Afternoon, everyone. It's 3:30. Let's get started. Today is our last day for requests for bill introductions, and we have quite the list, I think. Committee members, do you have any requests? Okay, I have two. I have one on behalf of bids. This is the bill that will increase the maximum rate paid to appointed counsel. We heard about that a couple weeks ago, and we had the update on public defense in Kansas. We've passed this bill out of this committee before, and but it's had to go on as a proviso because it hasn't made it through. So that one is RS 0995. Any questions or objection? That one in. The next one's on behalf of the Judicial Council. It's RS 0925. That's the Uniform Parentage Act. Kansas has been operating under the 1973 Act for quite some time, and this would update it to the 2017 Act. Any questions or objections? Get that one in. So from those here today who have let me know, let's start with Representative Ruiz.
Thank you, Mr. Chair. Thank you, committee. Have two. The first one is RS 0984, and this is on behalf of KDADS concerning the Care and Treatment Act, making changes to the assistive outpatient treatment program. Changes include extending initial hold duration, extending length of the treatment order, including psychiatric deterioration standards, and requiring sharing of the treatment plan with the court.
Okay, any questions or objection? We'll get that one in. Your next one.
Thank you, Mr. Chair. The second one is RS 0770. And this is on behalf of the state delegation of the multi-branch community of practice concerning forensic competency evaluations, allowing a judge presiding over a criminal case where a defendant has been incarcerated or involuntarily hospitalized, waiting for a competency exam for a period of time equal to the maximum potential sentence if convicted of the charged crime, to dismiss the criminal case and initiate an outpatient treatment order.
Any questions or objection? Okay, we'll get that one in. Representative Woodard.
Thank you, Mr. Chair. If the committee will allow it, I'd like to request introduction of RS 0934. You've heard of the court case Lawrence v. Texas. It's time to modernize the Kansas statutes to match that. So this is an act concerning crimes, punishment, and criminal procedure relating to criminal sodomy, members of the same sex, and removing the criminal penalty.
Any questions or objection? We'll get that in. Thank you. Representative Carr.
Thank you, Mr. Chair, committee members. I'm Representative Ford Carr from Wichita's 84th District. I would like to request the introduction of RS 1021, a bill concerning civil asset forfeitures.
Any questions or objection? We will get that in. Thank you. Sticking with asset forfeiture, let's go to Mike O'Neill.
Thank you, Mr. Chairman. Mike O'Neill on behalf of the Kansas Justice Institute. 23 RS 0736, an act relating to civil asset forfeiture.
Any questions or objection? Okay, thank you. We'll get that one in.
Mr. Chairman.
Melissa Kirshner.
Oh, sorry about that. From House District 53, and I would like to request introduction of 23 RS 0764, an act concerning protection orders. The draft bill would allow for the court to issue a restraining order to the plaintiff from abusing the defendant. In short, this would allow restraining orders to work both ways in Kansas when they're issued. I appreciate you allowing me the time today, and I'd be happy to answer any questions.
Any questions, committee? Ms. Kirshner, this is on your behalf, correct?
Yes.
Any questions or objection? We'll get that in. Thank you. Let's see, Ron Holm.
Thank you, Mr. Chairman, members of the committee. With your permission, it's 23 RS 0940. I'm here on behalf of the Kansas Family Preservation Coalition with support of the National Parents Organization and Americans for Equal Shared Parenting. What we have is an act concerning family law relating to legal custody, residence, and parenting time, requiring the court to adopt a parenting plan that maximizes each party's parenting time, adding misleading the court as a factor to consider when the court considers legal custody, residency, and parenting time, creating a presumption that joint legal custody and the temporary parenting plan is in the best interest of the child, and defining related terms under Kansas Family Law Code. Adding a failure to exercise parenting time is an action that may be considered material change of circumstances or altering a parenting plan.
Any questions, committee? Objection? We'll get that one in. Thank you. I believe that's all on my list. Yes, come on up. Representative Fairchild.
Thank you, Mr. Chairman. I'm requesting introduction of 23 RS 1036, allowing certain persons to take the examination to be certified by the Supreme Court as qualified to be a district magistrate judge. This was a bill that was requested by one of my constituents, Marshall Crispin, who's a former state representative.
Any questions, committee? Objection? Get that one in. Anyone else? Are there any Skippy, Natalie? Let's pause for a little second just to make sure we're not missing anybody, because this is the deadline. If you, yeah, you already. Okay. Well, if anyone shows up before the end of the day, we could come back to this before we adjourn. So let's move on for this for now. And I will open the hearing. We have one hearing today and then an informational briefing. So the first one is a hearing on HB 2215. We'll have Natalie come up and give us an overview.
Thank you, Mr. Chairman. House Bill 2215 creates the crime of utilizing a drug masking product, and it also provides criminal penalties for violation of that crime. Section 1 creates a new section of law. It would provide that utilizing a drug masking product means possessing, distributing, delivering, or selling a drug masking product. Violation is a Class A non-person misdemeanor. Section 2 amends KSA 215701. That's the statute that provides definitions to be used throughout Article 57 of Chapter 21, which is where all the drug crimes are. The changes there define drug masking product, which means synthetic urine, human urine, a substance designed to be added to human urine, or a substance designed to be added to or used on human hair, or oral fluid that is used or primarily intended or designed for use for the purpose of defrauding an alcohol or drug screening test. We also added new subsection T, which adds a definition of synthetic urine, which is a substance that is designed to simulate the composition, chemical properties, physical appearance, or physical properties of human urine. And I can take any questions.
Questions, Representative Carmichael.
Thank you, Mr. Chairman. Thank you, Ms. Scott. 3 questions come to mind to try to take them in order. It looks like the first section of the bill provides a definition of what is meant by utilizing a drug masking product, and it describes 4 different things, but it doesn't define actually utilizing the product itself to try to mislead a testing lab as part of utilizing. It's only, I guess you can only charge them with possessing, but am I missing something there?
Mr. Chairman, Representative Carmichael, so the utilizing there is kind of intended to be the name of the crime. So, in our criminal code, we have theft, which theft is, and then we describe what it is. So utilizing is not one of those 4 words, but I mean, if you possess it, if you distribute it, if you take it to someone, or if you sell it, then you would be in violation. The penalties don't change based on which conduct.
I'm not sure how you could possess it or how you could use it without possessing it. But then we get into that old argument about knowing versus unknowing. I don't want to go down that road today. So
Well, and so for drug crimes, we
Mhm.
have possession of a controlled substance.
Yeah.
We don't actually have a crime for
We don't have a crime of
using-
smoking marijuana.
Exactly. Yeah.
Thank goodness. The second question, though, does have to do with marijuana. It looks to me like this statute encompasses virtually everything having to do, or a whole lot of things having to do with controlled substances and what substances might be controlled and what aren't. I'm just looking for a germane place to stick a marijuana bill. I won't ask you to opine upon that. It just looked to me like it might be a real good place to run a marijuana bill on the floor. Third question, what's going on at the bottom of the bill where we strike the definition of possession?
Sure. Thank you, Mr. Chairman. Actually, I'm glad you asked that, Representative Carmichael. I meant to
Page
point
6,
that out.
line 4.
Currently, KSA 215701 has a statutory conflict because two bills passed last year that amended the same section, and we weren't able to reconcile that conflict before you guys adjourned. And so essentially what we do there is we publish two sections of law that have the same contents, but one shows the reflection from one bill, one shows the reflection from the other. So then we try to reconcile that conflict by putting the changes that we published in KSA 215701B into the base statute, KSA 215701, and then we repeal outright the conflicting section.
So this is here at the suggestion, if you will, of the revisor's office rather than Quest coming in and saying, we want a law that strikes the definition of possession in Kansas.
Correct. It's a technical change
Sure.
made, and just for everyone's information, that the bill that passed last year that made that change struck that section because possession is actually defined in KSA 215111, which is the definition section for the entire criminal code. So it was just repetitive to have it in both places. It caused us to have to make changes in both places instead of just one when we want to make the change. So.
And the way it generally works is once you have a bill that has the language where the conflict arises or where a change need be made, the policy at your office is, with the permission of the people offering the bill, is to try to fix it while you're in that portion of the statute.
Correct.
And that's what we're doing here.
Yes. Yeah.
Thank you.
Any other questions for Natalie? Okay, thank you, Natalie. We will begin with proponents. And Stephen, do you want to go first? Yeah, Stephen Durst is first. Either that or he jumped up when I said, do you want to go first?
Thank you, Mr. Chairman and members of the committee. My name is Stephen Durst, and I'm here testifying today on behalf of the Federico Durst Consulting Group and our client, Quest Diagnostics. Quest Diagnostics is one of several companies across the country that provide laboratory diagnostic and information services to healthcare providers, employers, and other similar organizations. Of note, Quest has a state-of-the-art regional hub and national operations center actually in Lenexa. It employs over 1,600 people, and it's a fantastic facility and something we really should be proud of. As mentioned, Quest provides services to medical providers and patients. So as an example, you've likely seen correspondence from Quest when you go to the doctor's office and you have blood work done. Typically see something from them processing for that provider. They also, Quest and other similar providers also run diagnostic tests such as urine samples on behalf of companies across the United States who require drug testing for employment or clearance for some sort of job they need to perform. They return these results to their clients, the companies, with what they believe is accurate information based on the sample they have received. Unfortunately, we have seen a significant uptick in fraudulent samples given by individuals, inhibiting diagnostic companies from properly doing their job and inhibiting employers and others from receiving the correct information they need to make decisions. And that's why we're here today. Just when you think you've seen it all in the Kansas Legislature, and just when Chairman Patton thought that maybe he had finally found that one bill that he would have thought of, that's why we're here today talking about synthetic urine. In all seriousness, it's a big issue. The proliferation of synthetic urine is a problem. Dr. Barry Sample, who will speak after me, will provide more detail on the steep increase in cases, many occurring in just the last few years. However, I will say this issue has been solved in 18 states and counting with similar legislation, and we are asking Kansas today to join that group. Mr. Chairman, again, I'd like to thank you and the committee today for allowing me to deliver some brief remarks. I'd respectfully ask if he's on the line, and there might have been some issue with that, but ask Dr. Sample to testify now, and I'll, of course, stand for questions at the appropriate time.
Very good. We're going to do Dr. Sample, then we'll do questions for both proponents. So we'll come back to you. Yeah, he is online. At least I see him, I think.
Thank you.
So, Dr. Sample, you're up next.
Thank you very much, Chairman Patton, Vice Chair Ralph, Ranking Minority Member Carmichael, and members of the House Judiciary Committee. My name is Dr. Barry Sample, and I'm the Senior Science Consultant with Quest Diagnostics Employer Solutions business. And as Mr. Durst indicated, Quest Diagnostics is in support of the committees on Judiciary's House Bill 2215. And I'd also like to add a little fact about the Lenexa, Kansas laboratory. It is one of the largest workforce drug testing laboratories in the country, in addition to all of the other items that Mr. Durst mentioned. So Quest Diagnostics has been tracking and reporting on the trends in workforce drug testing performed by its network of Substance Abuse Mental Health Services Administration. It's a mouthful. SAMHSA is how we abbreviate that, certified laboratories. And we do that through the Quest Diagnostics Drug Testing Index, or DTI, and that data goes back to 1988. During this period of time, overall positivity in the combined U.S. workforce has gone from a high of about 13.5% in 1988 to 4.6% today at the end of 2021. So does that mean drug use by workers is decreasing? Well, perhaps that's part of the story. Quest and government drug use data indicates that applicants and employees of companies with a drug testing program are much less likely to test positive for or use drugs by as much as 50% as compared to workers and applicants at companies that do not conduct drug testing. If we look a little bit deeper at our DTI data, between 2018 and 2020, the overall positivity rate on oral fluid drug tests was approximately twice that of urine. While in 2021, we saw this difference in positivity rates decline a little bit between oral fluid and urine. That's really at the overall level. And it was a result of a large number of employer customers dropping marijuana from their oral fluid panel. And since marijuana is the most commonly used illicit drug, it's not surprising that if employers remove that from the panel, you might see a decline in positivity rates. This long-term positivity rate difference is even more striking as we're comparing urine to oral fluid, given that the drug detection window in oral fluid is generally thought to be about 30 to 50% shorter than that in urine. And if we drill down further, looking at some of the specific illicit drugs, such as cocaine and methamphetamine, in previous years and in more recent years, positivity rates for cocaine and methamphetamine were twice as high in oral fluid as compared with urine. And in 2021, that delta increased to a four-fold difference, so four-fold higher in oral fluid than in urine drug tests for cocaine and methamphetamine. A key difference in these two specimen types is that oral fluid collections are directly observed, while urine collections occur in the privacy of the restroom. While one can't ascribe all of this difference in positivity rates to successful subversion of the testing process, the DTI data certainly suggests that products used to cheat the testing process are partially responsible. These products include substances that a donor consumes in order to dilute or cleanse I'll put in air quotes, cleanse their urine specimens. Products that are added to, that is, adulterate a specimen, and even more insidious, products, devices, if you will, that cannot be easily detected short of an observed collection. This last group, where devices are utilized, enables a donor to substitute a clean, negative urine for their own. And synthetic urine has become an increasingly popular means of eluting a positive urine drug test result. These products are typically comprised of uric acid, creatinine, salts, and coloring designed to mimic a normal human urine specimen and to pass standard laboratory tests of specimen validity. When combined with innovative delivery systems, warmers, heating pads, etc., they can effectively undermine the integrity of the drug test specimen collection process. Today, synthetic urine can easily be bought in head shops, via online distributors, and in some retail establishments. So while laboratories perform a variety of specimen validity tests, the anti-drug testing industry has responded with the continual evolution and sophistication of the products and devices used to defeat the drug testing process. In fact, some of them have such clever marketing, they even offer a money-back guarantee if the person who uses one of their products tests positive. Of course, that assumes that the donor would be willing to send their positive drug test result to the company, but giving a money-back guarantee, or in some cases offering for somebody to send in their old product and substitute it for the newest, latest version, talks about the sophistication of some of these purveyors of these products. So it really is a continual cat and mouse game, and the cheating industry continually works to develop systems that may not be detectable by the laboratories. An invalid specimen is one with an adulterant that can't be identified, or one with abnormally low indicators of dilution, or more recently, an indicator of a poorly made synthetic urine product. Over a 10-year period, the incidence of invalid specimens has doubled, and the majority, 73% of this increase has occurred in the last 5 years. And there are really two main effects of a laboratory reporting an invalid specimen result. An invalid result usually requires an immediate observed, at least in the federal drug testing programs, recollection of another urine specimen. This costs employers an estimated additional $1 million annually, not including the lost opportunity costs related to the delay in onboarding somebody. The more insidious cost of this impact of buying time is that it gives the donor time to clear the drugs from their system. Urine drug tests typically only have a 1 to 3 day window of detection. So specimen is collected, it is substituted with synthetic urine at the time of collection. Laboratory reports it is invalid. Between the time course of the testing and notification and getting the donor back in to be tested yet again, they've bought sufficient time that they may test negative. And what's worse for private sector employers is they generally don't test current employees, for example, with random testing. So this would represent a drug user that's been put to work and who is thereby putting either themselves or their coworkers at risk. As a scientist who's pursued drug test cheaters for a number of years, it is very frustrating to encounter this type of technology. And prohibiting the sale, distribution of synthetic urine, and other products that are designed to undermine the integrity of the drug testing system in Kansas will help to reduce drug test cheating, reduce cost to businesses and government, and provide confidence in test results. There really is no legitimate use for synthetic urine other than to subvert a drug test, and there's no reason for it to be available in the marketplace. Having a bill such as this will help protect the safety of our workplaces, roads, and transit systems, while also driving compliance with probation and parole drug testing and aiding in drug addiction recovery and treatment. Chairman Patton and members of the committee, thank you for your consideration of HB 2215. Quest Diagnostics encourages your support of the bill, and I'd be happy to entertain any questions you may have regarding my testimony. Thank you.
Thank you. Any other proponents? Okay, committee questions for the proponents. Representative Heiberger.
Thank you, Mr. Chair. I have a question for Dr. Sample. In your testimony, you mentioned substances that people could consume with the intent of diluting drug concentrations in samples. Is this bill intended to cover those substances like that? And if so, could you give a few examples?
Well, I would leave that to the sponsor of the bill to look at the language to see how directly it affects that. But I think generally it would be, because it's a product that's designed to subvert the testing process.
You give a few examples of what those substances might be?
Yeah. So typically these products in and of themselves really aren't that effective, quite frankly. Not as effective as synthetic urine or adulterants that can be added to the urine. These cleansing products, if you read their instructions, they may either be powdered form or liquid form, but they instruct the individual to drink a large glass of water prior to consuming their product. They are instructed to drink the product, which is again typically an 8 to 12 ounce glass of fluid, and then drink several glasses of water after consuming the product. So at the end of the day, what they're really doing is just consuming a lot of fluid. In and of themselves, these products don't really help eliminate drugs faster. They don't mask the drugs with those things that are consumed, but they do ultimately end up diluting their urine. And because administrative cutoffs are used for the reporting of positives, they may lower the concentration below those administrative reporting cutoffs.
Thank you. I just want to make sure we're not criminalizing water.
Representative Smith.
Thank you, Mr. Chair. Doctor, when your diagnostic center receives a sample, does that sample have documentation accompanying it with signatures on it?
Yes. So chain of custody is one of the basic tenets of workforce drug testing. So there's a signature of the donor. Now, depending upon the program, the laboratory may not receive the copy that is signed by the donor. It may go directly to the employer and not go to the laboratory. But there's certainly a chain of custody that is also documented by the collector. And then the laboratory follows chain of custody protocols within the lab.
And when they're signing that, what are they attesting to?
They are attesting to the fact, when the donor signs it, the donor is attesting to the fact that they provided the urine, that they didn't adulterate it, and that they then handed it to the collector. And then the collector similarly has a attestation statement that they received the specimen from the donor and sealed it in the donor's presence.
So they're inducing an official action by that. Thank you.
Representative Carmichael.
Thank you, Mr. Chairman. Dr. Sample, in response to Representative Heiberger's question, you said something that somewhat perplexed me. I think you referred the representative to the sponsor of the bill for the answer to the question. Now, our records reflect that the sponsor of this legislation is the House Judiciary Committee. That is us collectively. However, our records also reflect that this bill was introduced to the committee on behalf of Mr. Durst, your lobbyist, on behalf of your company. Are you all not the sponsor or the advocate for this legislation? And if so, to whom should I direct my questions?
So we are advocating for the passage of this bill. I apologize if I misled the committee. Perhaps I was
not
familiar with that process.
I'm sure you have to testify in many states, but I want to make sure we haven't made an error in our records. This bill was introduced on behalf of your company, and I assume your company still supports it. Is that correct?
That is correct, yes.
Then I have some substantive questions for you regarding the bill itself. Um, in my city, Quest Diagnostics is across town. I think it's in Representative Penn's district, but I'm not certain. But I have several retailers in my district who sell products that would be impacted by this legislation. And so, from a business standpoint and helping the businessmen and women in my district, I hope you understand that this legislation is contrary to their business model. Do you understand that concept, that this would impinge upon the business of small businesses who legally distribute these products at this time?
Well, I understand that it could potentially impact their ability to sell these products. The sale and use of these products impacts the ability of other employers in Kansas to maintain a drug-free workforce and to have a safe and productive workforce.
It looks to me, however, one of the products, by the way, that is sold in my district goes under a trade name of Gold Seal, but it's a flushing product, a diuretic principally. This legislation does not reach products like that, does it, sir?
I would have to look at the exact language in that. It's been some time since I saw that language. I apologize.
Okay. Okay. And the final question that I have for you, Mr. Sample, and maybe we can ask Mr. Durrest, who's here, he may be able to answer that question for us. But the final question that I have for you, I mean, ever since I've been in high school, people use so-called clean urine to avoid detection on a urinalysis type test. And for those of you who don't smoke weed, the way it works is you find somebody who does not use marijuana. They provide you with a sample of their urine. You then typically conceal it in your clothing near your body so that the temperature warms up to very close to body temperature. And then when you do the initial portion of the screen, you go ahead and urinate in the toilet, and then you take a bit from the donor specimen and you place it in the little jar, and then you slide that through the window. Does this bill seek to outlaw that long-standing practice that I learned about back in high school?
As I understand it, it's outlawing the sale and use of these products, right?
Well, it only outlaws the sale, I believe, of fake urine, not clean specimen,
Not
genuine
clean.
urine.
Right. It
Okay.
addresses
I don't know if anybody's dealing with urine.
addresses
Okay.
synthetic urine and I think other products that are designed to adulterate.
Okay, thank you. I appreciate that clarification.
I actually think it also includes human urine.
It does. Okay, then
So
I
your
overlooked
practice would no longer be allowed.
Oh, dear. I don't have any further questions. I do appreciate, Mr. Chairman, I missed that in reviewing the bill. Thank you for your help.
Other questions, Representative Osman.
Thank you, Mr. Chairman. I wanted to ask, are you aware, are people ingesting this in any way? I mean, other than the synthetic urine, are they ingesting it? Are they touching it? Is there a known proven health risk to this material?
Well, it's not designed for human consumption. I don't think anyone is ingesting it. I wouldn't expect them to. It's not sold, not packaged for that purpose. Generally, it would either be sold in liquid form, or it'd be sold in dry form, where the donor would then reconstitute it with water at the time of collection, and then substitute the synthetic urine for their own real human urine. And oftentimes those products may include some sort of thermal warmer, a chemical warmer that would warm the outside of the container that they're mixing it in prior to putting it into the urine specimen collection cup, or sometimes they may take the product and heat it up, for instance, in a microwave, and then keep it close to their body prior to going into the privacy of the restroom, and then decant that warmed specimen into their collection cup.
How are you aware that somebody's actually using these products?
Well, that's what's so insidious about these products. And quite frankly, there's a certain amount of we don't know what we don't know, because those products are manufactured in such a way to mimic the biomarkers such as creatinine, or looking at the pH, how acidic or how basic the urine is, or looking at the specific gravity, or in some cases, even looking at uric acid. So the industry that's producing these products knows the tests that laboratories are performing, and they develop their products that would have all of those same constituents within the normal range, so it wouldn't be flagged as a synthetic urine. Part of how we've uncovered this, one, as I mentioned, looking at our oral fluid versus our urine data. In oral fluid, much shorter detection window, typically 1 to 2 days. Marijuana, it's even less than that. Urine is thought to have a detection window of 1 to 3 days, or perhaps a little bit longer. But yet our oral fluid positivity rate is much higher than our urine positivity rate. Again, suggesting that something is going on. Those two are going in opposite directions. It is also discovered that at least a certain formulation of synthetic urine caused an interference with the one of the screening tests for the heroin-specific metabolite, 6-acetylmorphine. And one of the interesting things that we saw when the U.S. Department of Transportation and the federal government, for testing federal employees, added prescription opiates to the federal testing panel, we saw a big uptick in this immunoassay interference on the test for 6-acetylmorphine, that heroin metabolite. So even though heroin metabolite had been around in the testing panel for some time, tests for prescription opiates like hydrocodone and hydromorphone hadn't been. And then we suddenly saw this uptick in this interference, suggesting that people that had been using prescription opiates were now trying to use synthetic urine to pass their test. So it's mostly indirect evidence.
Understand. Mr. Chair, if I can ask just one more thing. I'm trying to make a determination here, because as I see, there is, one of two possibilities. Either you can detect it, in which case your tests work and you are able to make a determination that somebody is trying to subvert the system, and then and take appropriate measures, or you can't make that determination, in which case we're asked to, modify legislation based upon information that we do not know how wide or extensive this issue or problem is. And I was hoping that you might be able to help address that, in terms of how do we know that this is a problem? We know that it is being sold, but it is not harmful to people. And we don't know how often it's being used, or how often it's being subverting the test, or whether there's an issue in general about usage of it. So if you could please comment on that.
Sure. Well, I would suggest that the data from oral fluid and urine testing certainly suggests that something is going on when you have an observed collection with a much shorter detection window, as compared with an unobserved collection, the privacy of the restroom, with a longer detection window, and you have much higher positivity rates on those oral fluid tests than you do on urine tests. That certainly at least suggests to me that something is going on. And we've seen, that delta in positivity rates increasing, particularly in 2021 as compared with previous years. And, unfortunately, because of the nature of these synthetic urine products and the tests that the laboratory is performing, it's possible to make a synthetic urine that mimics all of those constituents that laboratories are using to assess whether it is urine or not. That's why it's so important that Kansas join the other 18 states that have enacted similar legislation that would prohibit the sale of these types of products.
Representative Vaughn.
Thank you, Mr. Chair. This question could be for Natalie or for Mr. Durst. I wanted to clarify that the violation of this law is a Class A non-person misdemeanor for simple possession or distribution, intent to sell, or I had the list pulled up here. Let's see. All of those things. So there's not a differentiation between just possession and then actually selling.
Mr. Chairman, Representative Vaughn, that is correct. So there's whether you possess it, you sell it, you distribute it, or you deliver it, it's a Class A non-person misdemeanor. It doesn't disambiguate between those actions for purposes of the criminal penalty.
Okay, thank you. I was just asking, Class A non-person misdemeanor seems relatively punitive, in my opinion, for simple possession of fake pee, essentially, and using that. And so I don't know if the person testifying would be interested in extrapolating or kind of talking about why that was done and why that's not differentiated. Thank you.
Mr. Chairman, Representative Vaughn, no reason other than, that's in working with the revisor's office, that was what we had seen. Different states classify misdemeanors in different ways, but I would certainly be open to what we would probably consider a friendly amendment if we wanted to adjust that. And I actually had some conversations with folks just prior to this bill being introduced about maybe moving that to a Class B, I think it was. So we'd be very open to that.
Representative Humphreys.
Thank you, Mr. Chairman. I'm thinking this is for you, Stephen. So, so just along all of these same lines, I mean, I think Dr. Samples made it really clear that the masking material is not detectable in their test, and so it seems like it really boils down to selling more than anything else, or because possession. I mean, I'm just trying to see if you would agree, because if they can't tell after the fact, it has to be when the selling. I mean, I guess possessing if in the moment, but of course that this is all done in private. And then my second question is, does this include human urine that you've just got on your next to your body? So how does it's not masking, it's cheating the test, but it's different than what you have here. But he talked about that people do that also. So how does that play into this?
Yeah, Mr. Chairman, Representative. So I think the bottom line on this is, to answer your first question, it's fraud. It's fraud, whatever way you look at it. You are attesting that you have a sample that has been produced by you for whatever purpose, and when in fact it is not you who produced this sample, right? So I think that is what a company.
Not catching that person, right? I mean, in the moment we're not catching it because it's not detectable,
right? And so I think this is meant, and we've seen it in other states, as I mentioned, but it really is meant to be that extra layer of deterrence, so that individual, they give another thought to subverting this test for maybe just a couple of days, and it really is throwing a wrench into diagnostic companies, but more than that, it's employers and it's law enforcement and it's whoever you might need these tests. And so I think it is just that extra layer of protection. And there are laws that provide that often, and will it work 100% of the time? Probably not, and most laws don't. But again, hopefully this causes people to pause and think. And to your second question, I would probably direct that to Dr. Sample. But again,
Okay.
he's probably better suited for that.
Yeah, and if he could answer, that would be great. Thank you.
Could you repeat that part of the question, please?
Yeah, the question is, does this bill include the fraud of bringing human urine in with you to the testing area? It's all in private. So, we know this is the masking, but part of the problem is a different way of cheating.
As I understand it, it's about selling and distributing it. Again, I'd look to Mr. Durst or the author. I didn't author the exact language in the bill.
Mm-hmm.
Let me just give me a second, and I'll certainly read over again and make sure that I'm giving you an exact answer or correct answer.
Okay.
Thank you.
Thank you, Mr.
Representative Owens.
Thank you, Mr. Chairman. So my question is, as we're trying to thwart the use of synthetics or things that would cover for a drug test, are we, as I understand, there are a lot of natural options out there to cover up drug use. Matter of fact, I had a brother about 24 years ago, and I had to ask him why he continued to chug dill pickle juice for days on end as he was applying to get into the military. Come to find out, he was doing it to cover up a cocaine habit that he had at the time, and apparently it worked pretty well. Now, kids, don't try that at home. However, I'm just wondering if a substantial amount of dill pickle juice showed up in my urine, would I be in violation of this law?
Was that a question for me or a rhetorical question?
Well, no, I mean, I understand what we're trying to get at here, right? As people that are thwarting the system. So if they use a natural remedy or a natural solution that is then detected in my urine sample when it is tested, are they then in violation of the law? And I don't think that's just whoever can answer the question. I'm just trying to understand. I mean, I know what we're getting at here. Just trying to understand it thoroughly.
I believe the answer is no, Representative Owens, but let's have Natalie confirm that.
Thank you, Mr. Chairman. So I would direct all of you to on page 2, starting on line 32. That's where we define what a drug masking product is. So it means synthetic urine, human urine, a substance designed to be added to human urine, or a substance designed to be added to your hair or other oral fluid. So, pickle juice, those type of diuretic type things would not be covered here. But I do think that human urine, kind of related to Representative Humphrey's question, would be included. And then if you look over on page 6, I think, is where we define synthetic urine too. So.
Thank you.
Representative Goddard.
Thank you, Mr. Chair. Just a comment. I certainly hope dill pickle juice doesn't come up in this because it cures my hiccups.
Representative Osman, did you have a question? No? Perfect. Representative Munn.
Thank you, Mr. Chairman. This may be for Dr. Sample. I know we can't define or include a full list here of all items that would be covered, but I'm concerned, are there any legitimate uses for some of these items that you were discussing that could fall under this bill, or are these the only use would be to treat the sample?
So I can't envision synthetic urine having a legitimate use, being sold over the counter to the general public. I can't imagine oxidizing adulterants such as chromium-6, which is quite toxic to humans and should never be ingested, but is added to urine in an attempt to thwart the drug test, or nitrite, or adding bleach products. So there are, a number of adulterants that are added that aren't suitable for human consumption, that are marketed. Well, in some cases, they may talk about them being cleansing agents. They're really marketed with the intent to defraud those drug tests.
Yeah, I appreciate that. I always worry about us outlawing something, having the unintended consequence. So I appreciate your answer. Mr. Chairman, just another couple probably for Natalie. And I apologize if this was asked by my friend from Wichita, the ranking member, as I was walking in, but it appears that this bill also changes it deletes the definition of possession. And did I miss something that you explained previously?
Yeah, Mr. Chairman, Representative Mon. So the reason we're doing that is simply to cure a statutory conflict in the law. So it's actually current law right now. If you went to the statute books, you would have a KSA 215701, and then you would have an identical looking section 215701B, except that one would strike the definition of possession. So essentially, we're just putting those changes from that section into the base section and repealing.
Okay, I appreciate that. I did, as I was walking in, I guess you were explaining that, so I apologize for wasting everyone's time. The last question is, wouldn't this be covered by possession of paraphernalia?
Mr. Chairman, let me bring up that section.
While you're looking, Representative Owens.
Thank you. And Stephen, maybe you can answer this question. So again, I'm trying to understand who really wants this to happen, because I assume the drug tests are primarily done for the benefit of some industry, some company, some whatever. Are they the ones that are overly concerned about this and wanting this to be criminalized, or are they really of the perspective that we need employees and I hope that they can pass their drug tests, so if they use this, they're actually better off? So is the industries itself clamoring for this legislation?
Yeah, so Representative, Mr. Chairman, I will see if I can't find, again, clients of the client that we represent that may have had a real issue. I can imagine there would be, but I don't want to give you misinformation. And then, yes, I think it goes back to diagnostic companies providing information to these, their clients that is then incorrect because people are thwarting the system. And so in order to cut down on that, and I think Dr. Sample alluded to it, out of safety in many cases, pass legislation like this that, again, will make people think twice. But I certainly can see if there are any clients that would provide anecdotal testimonials of, hey, this was not a good thing, that we received information back that was incorrect.
Thank you. A follow up real quick. How many other states have taken this action? Do you know, or have any?
So in my research, and I will get you the most up-to-date figures, but as of July 2022, there were 18 states that had taken similar steps. Now that sessions have gotten going across the country, that number may have changed a little bit, but those are the figures I had.
Thank you. Thank you, Mr. Chairman.
Natalie, do you have an answer?
Thank you, Mr. Chairman. So I reviewed both the definition of drug paraphernalia and the crime that criminalizes possessing it. If you look at the definition, which you would be able to see in your bill there, it's subsection F. Essentially it covers a lot of verbs, equipment used for, but then it says introducing into the human body a controlled substance. So it doesn't sound to me, based on the testimony, that would be what these products are designed to do.
Thank you, Mr. Scott. Drug paraphernalia definition includes items that are used for concealing items that are injected or inhaled, injected otherwise into the human body. And so I just wonder whether this would fall under concealing drugs, basically. And I mean, I get your point. I'm loath to start adding more and more laws if we can simply enforce some in a different direction. But I appreciate your explanation.
Representative Smith.
For a second time, thank you. In response to Representative Owens' question, as a law enforcement administrator, I think I can bring the idea that most people would not want to see law enforcement thwarting the system with a methamphetamine addiction or a cocaine addiction by being allowed to adulterate their urine samples and cover that up. And I think most people, it wouldn't be a giggling thing if somebody was getting away with that in law enforcement. And I can tell you that if I caught one of my officers bringing something like this in, it would immediately become a fruits and instrumentality of trying to commit the crime of making a false information, which is a level 8 non-person felony, because they're signing saying they're providing a sample. And so it does become very important to our industry.
It's the last question for the proponents. Representative Carmichael.
Thank you, Mr. Chairman. That's one thing I agree certainly with Representative Smith about, is that there are some avocations where clearly we wouldn't want this sort of thing going on. But more importantly, I think it's already a felony to do this. I think it's the equivalent of making a false writing. If you certify it's my urine and you give it to the testing lab and it's not your urine, I think that's fraud, and I think it's actionable. And I'm not sure that this misdemeanor statute is going to deter anybody. Thank you.
Okay, one last question. Representative Lewis, since you haven't asked one yet.
Just as a short rebuttal, this criminalizes though somebody that's selling the product. What you're talking about is somebody who uses the product and makes a false statement.
Good point. Okay. Any neutral conferees? I know we have one opponent online, Nick Reinecker.
Mr. Chairman, can you hear me okay?
You can, yes.
Very well. Mr. Chairman and committee members, thank you for allowing me to speak today. My name is Nick Reinecker, a private citizen from Inman, Kansas, here today in opposition of the current language of House Bill 2215. For the new legislators of this committee, I've been advocating for constitutional cannabis in many committees of the Kansas legislature for the last 10 years, and I'm grateful for the opportunity to participate in this process as a taxpayer, as a husband and father, and as an individual. And Mr. Chairman, I wouldn't call myself a scholar yet, but it is amazing what I've learned and been exposed to in regards to the political process and content thereof. I'm an opponent to House Bill 2215 due to the violation classification and definition of utilizing a drug masking product. I believe if there is going to be what I like to call a deception crime, then it should be consistently classified like current statutory language. Whereas if one is distributing, selling, or delivering a drug masking product, it is more reasonable that it should be a felony. For possession of a drug masking product during roadside testing, where driving is a privilege and not a right, a Class A misdemeanor does in fact seem appropriate. For pre-employment testing, I would rather have it be an infraction like a minor in possession of cigarettes, but I too can compromise. And for my favorite scenario, the possession of a drug masking product during probation and or parole, well, I guess it wouldn't be parole, regarding first-time conviction of possession of cannabis, which is a Class B misdemeanor, I do not agree that the possession of a drug masking product to mask cannabis use should be subjected to a higher violation classification. I do not like deception. However, I also do not like the way a substance's mere presence implies impairment, and we are seeing this being eliminated in states and industries that are discontinuing the testing of cannabis. Policies like this could disparately target the low-hanging fruit of a metabolite that remains far longer than any impairment could ever be articulated. This does not even consider the realities above the realm of black and white law, where the workforce in retail, food service, and trucking, those individuals who keep this country running, are the ones most likely impacted, will most likely be impacted by this fruit of the unconstitutional prohibition of cannabis and the possession of a drug masking product to mask the use thereof. Also, the word illegal should be added to drug masking product, for there is no testing of caffeine impairment, but I will leave that rabbit trail alone. Mr. Chairman, I value this committee above all others and have always felt respected and have never felt talked down to or bullied. So I will stop my philosophical commentary and ask that you would look at the attachments to my testimony for more underlying issues that I believe are germane to this policy trajectory, including the study, The Next Day Effects of Cannabis Use, a Systematic Review, and Prescription Drug Use Among Police by the International Association of Chiefs of Police. And finally, I am compelled to say I would completely remove any opposition if all possession of controlled substance crimes were classified as felonies and cannabis was removed from the Kansas Controlled Substances Act. Please consider these changes and thank you for allowing me to speak. I will stand for any questions at the appropriate time.
Thank you, Nick. Any questions, committee? Okay. We have written opponent testimony from Sean Randall on behalf of the BIDS Legislative Committee. Any other opponents? Not seeing any. I will close the hearing on House Bill 2215. Committee, we now have an informational briefing on supported decision-making. If you've been on this committee very long, you'll recall that we've had hearings and actually worked in committee a bill on supported decision-making. There is a bill that's been introduced and assigned to our committee. This is not a hearing on that bill. Instead, this is just an informational briefing on what is supported decision-making, why the proponents think it's a new tool that they should have, why the existing tools are not working, not really tools, but guardianships, powers of attorney, those types of things. Mike Burgess, come on up, Mike. Mike is the Director of Policy and Outreach with the Disability Rights Center of Kansas, and he's kind of going to lead this presentation for us.
Yes.
Just going to hand it over to you.
And we will do our best to try and get through. I appreciate the chair. You actually stole some of my thunder. I was just going to describe what we were going to talk about today, and you did a very eloquent job of describing what we were planning to present today. So I appreciate the opportunity. We're very fortunate to bring in some of the foremost experts on supported decision-making in the country, and they've been on WebEx this whole time. But without further ado, I guess I would like to introduce Jonathan Martinez, and I'll let him cover his bio and his background a little bit on it. But he's going to talk a little bit about, again, all those things, why it is needed and how it is different than those other tools that the chair just mentioned. So with that, I'll turn it over to Jonathan.
Thank you, Mike. Good afternoon, Mr. Chairman, members of the committee. My name is Jonathan Martinez. I'm the Senior Director for Law and Policy at the Burton Blatt Institute at Syracuse University. I'm honored to be here today on my own time and without using any federal funding. I was told that my job today is to tell you what supported decision-making is and why it's important. And that's an awkward one because you already know. You already know because you use supported decision-making, or as we call it, SDM, every day. When you confer with staffers or your colleagues or constituents about whether to support a particular bill, when you ask for advice from professionals to do your job as well as you can, when you ask doctors to speak in plain language, and when you get advice from your friends in personal matters, you're using SDM because you're getting what you need to make the decisions you need to make. That's all SDM is. It's working with people you know and trust to get the information and input you need to make the best decisions. That's it. And you already know why it's important, because when you use SDM, you're doing the right thing, both for yourself and for society at large. Think about how society values SDM. Think about all the sayings and cliches we have about making decisions. Get a second opinion. Don't make a snap judgment. Do make an informed choice. My dad always used to say, if you measure twice, you only have to cut once. So when you use SDM, you are seen as wise or careful or judicious. And that's important because in the end, you are the one making the decision based on your values and the information you sought out and received. That's your right to make choices. And think about how many of your rights come down to choice. Freedom of speech is the right to choose what to say. The right to vote is the right to choose our elected officials. The rights to life, liberty, and the pursuit of happiness are the rights to choose how, where, and with whom we live. So SDM makes your rights real. Without choice, without the right to make choices, there can be no real rights. And your right to make choices, to make good choices, to make informed choices, in large part depend upon your right and opportunity to get help making those choices from your friends, from family members, from professionals. And unfortunately, as you're going to hear today, people with disabilities are not viewed as having the same rights as everyone else. Even though Kansas and federal law say that you must have equal rights and protection, where you are seen as wise when you get help, they are too often viewed as weak. When you are seen as exercising your rights when you seek support, they too often lose their rights because they need support. And that's why I'm honored to be here today, to ask you to recognize, respect, and protect people with disabilities' right to use SDM. The same rights that you have, that every American citizen was promised by our founding documents. But that, as you'll hear today, far too many have needlessly lost. Today, you're going to hear from local, state, and national experts, and me, about the benefits of SDM and the need for it. You'll hear about the scientific background and basis of SDM, how it's based on 4 decades of research showing that when people with disabilities have and exercise their right to make choices, when they have more what we call self-determination, they have better lives. They are more likely to be employed, live independently, be active in their community, and be safer. You're going to hear about national and international trends in SDM, how 23 states and the District of Columbia have already passed laws doing exactly what we're asking you to do today. Protect people with disabilities' legal right to use SDM to make decisions. But here's something you're not going to hear. You're not going to hear me or anyone else say that there should never be guardianships or that existing tools are bad. That if you protect people's right to make choices using SDM, that doesn't mean that there will never be guardianships. It doesn't mean that there can't be powers of attorney. It doesn't mean that parents can't work with their children. And it doesn't mean that people in guardianships or who have powers of attorney will lose them. That would be wrong, and we would not ask you to do that and are not. Instead, what you're going to hear is how people who can use SDM have used it, and ways that if you protect their right to do so, Kansans will exercise their right to use SDM and make choices. You'll hear about the benefits people who use SDM and make their own decisions have experienced. Here's just 2 real quick. In a study that I led in Virginia, we found that people with disabilities who used SDM to make their own choices were more confident, more independent, were better at making decisions, and made objectively better decisions according to the people in their lives. And second is a national study you'll hear about that found that among people with similar abilities and limitations, or as I call it, apples to apples, those that had and exercised their right to make their own decisions were more likely to work, live independently, socialize, date, marry, and be respected in their communities than those who did not. Think about it. Working, living independently, getting married, being respected. Those aren't just Kansas values. Those are bedrock American values, and that's why we're here. To ask you to protect, respect, and recognize people with disabilities' rights to do what all Americans should have the right to do. What the Americans with Disabilities Act, sponsored and championed by Kansan Robert Dole, promised them the opportunity to do. Be full and equal members of society. Thank you.
And thank you, Jonathan. And we had intended to show, there was a brief video. It's literally 2 minutes and 47 seconds. I think just for the purposes, given the time, that we will skip that today. If you all will promise to watch it on your own later, I will share the link with you. It's very brief, and it basically takes a lot of what he said, but frames it from the perspective of individuals with disabilities in plain language. And so it's a great resource both for you to kind of hit home what we're talking about today, as well as something to share with your constituents and others who might benefit from using supported decision-making and alternatives to guardianship. And so with that, we will jump next to Evan Dean, who's with the KU Center on Developmental Disabilities, and I'll turn it over to Evan.
Thank you, Mr. Chair and members of the committee. And I do want to give a plug for Mike. I do recommend everybody watching that video. It's very informative and impactful. But my name's Evan Dean. I'm an associate director at the KU Center on Developmental Disabilities, which is a recognized leader in research on self-determination and supported decision-making. And that the team includes our director and my colleague, Carrie Sjogren, who along with Jonathan, who you just heard from, and a couple of other people, authored the first textbook on supported decision-making and conducted many of the early studies on supported decision-making. So I'd like to talk with you about some of this research, and also, as Jonathan said, the last 40 years of research on self-determination, and talk about why these research shows that these conversations are important. And mainly, as Jonathan said, making decisions in our lives is an opportunity to build and to use our self-determination. And as research over the last 40 years has been really clear that when people have increased opportunities to make decisions in their life and build self-determination, they are healthier, employed more often, and safer because they're better able to recognize and resist abuse. Further, research has shown that people under guardianship who inherently have less opportunity to make decisions in their life are then less likely to live in their own home, less likely to work, and less likely to have their rights respected. Now, these findings are particularly concerning for Kansas, where rates of guardianship are rising and are well above the national average. And while guardianship, as Jonathan said, can be appropriate for some, use of overbroad and undue guardianship is growing. And in fact, young people are the most likely to enter into guardianship. Youth aged 18 to 22 with intellectual disability or autism are most likely, even more than people over 75, to be under guardianship arrangements. Now, a common practice when students with disabilities become adults is to present students and families with legal guardianship as the primary means for families to maintain involvement in decision-making over education, medical, and other post-school decisions, which creates what the National Council on Disability has termed the school to guardianship pipeline. Now, this pipeline is problematic for most because it diminishes the right and the supports for decision-making, reducing opportunities to develop self-determination and to achieve the health, employment, and safety outcomes that we want for all Kansans, especially Kansans with disabilities. So with that, I will turn things back over to Mike for our next speaker.
Thank you. And thank you, Evan, for framing a little bit of the problem and talking about the school to guardianship pipeline that exists. But unfortunately, that's only part of the costs, or the impact on self-determination is only part of the costs of overuse of guardianship. And so next we have Elizabeth Moran, and she's going to elaborate a little more on the cost to the court system of guardianship, and not just on a one-time, but it's the cost that keeps on going too.
Thank you, Mike, and thank you, Mr. Chairman and members of the committee, for the opportunity to join you in this important conversation. It's great to be back in Kansas, even if only virtually. I am currently executive director of the ARC of Colorado, but prior to my joining the ARC team here, I served as chief counsel at the American Bar Association's Commission on Law and Aging, where I provided substantive support and expertise to the commission on guardianship law, policy and practice, reform at both the state level and the federal level, specifically in the areas of guardianship, supported decision-making, issues around adult capacity, abuse, neglect, exploitation. And my first sort of testimony to the importance of supported decision-making in Kansas was as an active attorney in both Kansas and Missouri, where I was litigating on behalf of adults with diminished capacity, typically in defense against guardianships or seeking restoration of rights on behalf of individuals with diminished capacity who are subject to overbroad or unnecessary guardianships, or removal of guardians or appointing successor guardians in cases of abuse, neglect, and exploitation. As the public policy coordinator in Kansas back in 2016, I partnered with the Kansas DD Council and many of the folks who were on this call, and we hosted the first ever supported decision-making conference. It was wildly popular, and when I think about that, and I think about that being 7 years ago, and we're still just now trying to really reach out and do some legislation and policy and practice and make it a regular part of decision-making supports for individuals. It seems like a long time to have made so little progress. I'm really hopeful that we'll make more progress as we move forward. I want to talk about three things. I want to talk about ongoing costs. I want to talk about national and international perspective briefly, and then of course about supported decision-making under the Kansas statute today. The first thing I would encourage you to be mindful of is the impact on the capacity of courts to handle these cases, the costs both to the individuals who are subject to guardianship, to the folks who are filing these guardianships, to the folks who are reviewing annual reports, annual reviews. Someone has to do that, making modifications. I think often we focus too much on just the very beginning of a guardianship case. So how much does it cost me to petition, right? And what that doesn't take into account are the ongoing costs, things like filing those reports, making changes to that guardianship, seeking restorations when that is possible. What happens when the guardianship is no longer able to fulfill their duties and responsibilities? That's yet another change that someone has to pay for. But it's very, those courts get overwhelmed both by cost, taxpayer money paying for those, but also keeping folks sort of in that government, that judicial process when something less restrictive may be available and more appropriate for those individuals. During my time as chief counsel at the ABA, I was privileged to have a bird's eye view of supported decision-making across the nation. As Jonathan Martinez alluded to, by last count, I believe there are around 23 states that have passed supported decision-making legislation. And many states have also created centers for decision-making supports, which is sort of a one-stop shop that helps families better understand what supported decision-making is, to battle that pipeline that Evan just talked about. So helping families understand, how do I engage in supported decision-making? What is a supported decision-making agreement? How do I create those integrated supports for my loved one? I was also privileged to participate in the 4th National Guardianship Summit that was in May of 2021. This event happens only once every 10 years. And it's the State Justice Institute and the National Guardianship Network. They bring together 125 advocates, guardians, lawyers, judges, scholars on a conference. And they really look at reform and improvement around the theme of maximizing autonomy and ensuring accountability. Importantly, I want to talk to you about a recommendation. There were 22 recommendations that came out of that summit, and it's recommendation 2.3. And it reads like this: statutes, court rules, policies, and processes in every state should require courts to consider supported decision-making as one of the alternatives to guardianship at appointment, and periodically thereafter by requiring that petitioners for guardianship plead affirmatively that supported decision-making as one of the alternatives has been tried or why it is not feasible. Before guardianship can be imposed, the court find by clear and convincing evidence that supported decision-making is not feasible, and that courts institute procedures for periodic review of the need to continue guardianship, which includes an affirmative determination that supported decision-making and other less restrictive alternatives are not feasible. And then finally, sort of my last hurrah at the ABA Commission on Law and Aging was serving as an American delegate representing the American Bar Association for the 7th World Congress on Adult Capacity. This was held in Edinburgh, Scotland this last June. And I should tell you that so many countries have made changes in how they approach guardianship and supports for honoring a person's will and preference, that the Congress used to be called the World Congress on Adult Guardianship, but because so many countries have made changes, they now call it the World Congress on Adult Capacity. So to use one of the Congress's most prestigious plenary speakers, Professor Wayne Martin from the University of Essex, he says the world was watching Scotland as they brought together 274 delegates and 30 different countries from around the world. Overwhelmingly, my biggest takeaway from Congress was the contrast between countries who are commonly regarded as similar to the United States, but in many aspects are much more forward-thinking and rights-based in their legislative regimes, policies, and practices than the United States. Nearly every plenary breakout session, panel discussion centered on the UN Convention on Rights of Persons with Disabilities. If you're not familiar with it, I'll be sure to get Mike a copy for you all to read. Indeed, the world is watching, but what does all of this have to do with Kansas? Well, Kansas has what I call one of the most ideal statutes for supported decision-making. So under chapter 59-3051, which are the definitions, who is an adult in need of a guardian? So an adult with an impairment in need of a guardian or a conservator or both means a person 18 years or older, this is important, whose ability to receive and evaluate relevant information, and I would argue that often we don't provide them effective communication supports under Title II of the ADA to allow them to meaningfully engage in that communication. Put that aside for a second. Or both, even with the use of assistive technologies or other supports, right? So other supports is in your statute. There's room for supported decision-making there. So a person should not, according to Kansas law, cannot be put under guardianship unless he or she cannot evaluate information, communicate decisions, or meet their needs, even with the use of assistive technology or other supports. And I would argue those other supports include certainly supported decision-making. I think it's important that we really work to identify and advise on integrated supports, both decision-making supports and day-to-day living supports. This would greatly reduce, if not eliminate, the need for guardianship. It would lessen the impact on courts. It would certainly clean up the docket a little bit, provide a little more room and a little more time. And also, I just think it's important that we make it a priority to develop, provide, and assist individuals with disabilities their freedom of choice, their autonomy, and the dignity that supported decision-making provides. So in closing, I'll just say this because I know I'm out of time. Supported decision-making is at the heart of liberty and justice for all. It is at the heart of the pursuit of happiness, and it is honoring an individual's civil and human rights. And to use the words of the United States, our late Justice Ruth Bader Ginsburg, real change, enduring change happens one step at a time. And I believe the time in Kansas to start taking those steps is now. Thank you for your time.
Thank you, Elizabeth. So we've talked a little bit about what it looks like both internationally and nationally to some extent. So what we're going to talk about, and as you heard too, that we already have, our laws already allow for supported decision-making today. But, why are we having this hearing? Part of that is so you can see what it looks like. And next, Craig is going to talk a little bit about that because it can be both used formally with written supported decision-making agreements, or it can be informally. And then after Craig, we'll hear from Colin, who's an individual who actually uses supported decision-making today. But Craig is next.
Chairman Patton and members of the committee, on behalf of the Kansas Council on Developmental Disabilities, thank you for the opportunity to speak to you today about supported decision-making. My name is Craig Knutson. I'm policy analyst for the council. Supported decision-making is the embodiment of individuals' right to have the opportunity to make choices about their own life, a right each and every one of us takes for granted. If there's one thing I hope that you take away from my testimony today and the testimony of the other conferees, it is the fact that supported decision-making is natural. And it is an accommodation for people with intellectual and developmental disabilities, much like wheelchair ramps and curb cuts are accommodations for people with physical disabilities. Supported decision-making is something we all do whether we realize it or not. If you've ever used a financial advisor to help with your investments or have consulted with an accountant when doing your taxes, you've used supported decision-making. Some of these supports may be formal and legally binding agreements, and sometimes the supports are informal in nature. Both work in supported decision-making and should be tailored to meet the individual needs of the person. In the council's written testimony, you'll find two important resources of supported decision-making in practice. The first resource is the state of Wisconsin's supported decision-making agreement. Supported decision-making agreements can either be informal or formal agreements. But as you will see, even formal agreements don't have to be overly complex. The Wisconsin example is a simple form that is easy to understand and clearly outlines what a supporter can and cannot do when engaging and helping with supported decision making by asking a few very basic questions that outlines when a supporter can and cannot provide support in the decision making process. Now, some of us might need more help with certain decisions in different areas of our lives than others. Sometimes we have a good understanding of where we need help to make decisions, and other times we need accommodations to help us understand if we can decide on our own, if we need to support it with a decision, or if we actually need someone else to make that decision for us. Also included in the written testimonies today is a second tool that Kansans can use to explore and discover the areas of life where people make choices and decisions and then decide how much support might be needed for making and communicating those decisions. The Charting a Life course, Exploring Decision Making Support Tool, allows users to explore various life domains such as daily life and employment, healthy living, like going to the doctor, social and spirituality, like if you'd like to go to church, who you'd like to interact with, safety and security, community living and advocacy and engagement. These are different life domains where we have decisions and we might need support deciding how we want to approach those. This tool helps individuals and families design unique agreements that meet their individual support needs. Once someone identifies where they need help and support to make decisions in their life, whether those decisions are big or small, they can develop a support network to help them understand options so they can make an informed choice about the events and activities that impact their life. This support network agrees to help the person make informed choice, but they let the person with a disability make the choice rather than someone else make the decision for them. While formal supported decision-making agreements are not currently recognized in Kansas, current statute, as Elizabeth mentioned, around guardianship does allow for informal supported decision-making opportunities. And with that, I'll go ahead and turn it over to Mike, who will introduce someone who's using an informal agreement currently here in Kansas. Thank you, and I'll be open for questions at the appropriate time.
And as Craig said too, I mean, often you don't have to wait until an individual is 18. You can start today, so you can advise if you have friends and family or others, constituents of parents with disabilities. It can start with, how do I eat a healthy diet, or what clothes to wear on a given day based on the weather outside. That's something I battle every day with my kids on a daily basis. And, sometimes you have to let them make their own choices with those as well. But the cool thing is we actually have a certifiable expert who uses supported decision-making today. And without further ado, I'd like to introduce or turn the mic over to Colin Olenek with the Self-Advocate Coalition of Kansas.
Thank you. My name is Colin Olenek. I do use supported decision making. In my written testimony, I've given examples of me working with my dad or my personal care attendant to make everything from financial, specifically with my ABLE account with my father. He understands investments more than I do, so I consult with him on these things. Shelly, my PCA, helps me with everything from understanding medical to how much money I've got in the bank to, what type of cat food I should buy for my cat. I just, it's a daily thing for me. And the legislation and concept that we're talking about, this would just formalize it even more. It would, in the case of specifically my AWOL account, I have a durable power of attorney in which my dad has. It took him, 2 days to find the appropriate form that the AWOL account people would recognize. If this legislation that we're talking about were enacted, we could write a form ourselves, or we could print off a template from a singular website. And so we wouldn't have to be looking, and the cost is zero. I mean, I've gotten stuff. All we're asking for is a notary public, and I can get that at my bank, and you know, so I mean, it's pretty easy if you allow people to make their own choices. Sometimes they are going to make mistakes, and that's living. That is life. This is just a way to formalize it and to make it easier for people to live their lives. And I will stand for questions at the appropriate time.
Oops. And thank you, Colin, for sharing that. And kind of one of the key things that I just realized that we kind of hadn't fully covered yet is the difference. So you have, Colin mentioned the durable power of attorney, and that's a legal document that's typically drafted by an attorney. And the cost that you would pay for a durable power of attorney will vary depending upon that attorney. If you are an individual, you can go and Google power of attorney trying to figure out what you need, and 4 hours later, you may or may not be any closer to figuring out what you really need. But it is a powerful tool, but it outlines the situations for a substitute decision maker. And that's probably is the key difference with this, where with supported decision making, the decision maker consults with their friends and people they trust, but they're the ones ultimately that make the decision. With most of these other instruments that we've talked about, those set up a substitute decision maker, outline the times or situations when a substitute decision maker can act on your behalf. And that is the key difference with supported decision making versus a durable power of attorney, a rep payee, even a guardian or a conservator. And with that, I'd like to turn it back over to Jonathan, who's going to share a little bit about, because one of the reasons we're talking about this today is there are a number of states that have passed legislation around that, talking about the benefits of legislation. And so and then also he's going to then also talk about why this matters. Because at the end of the day, we've covered a lot of different ground, but you want to bring it all back to why we're here today having this discussion, and appreciate your time. So thanks, Jonathan. Take it away.
Thank you again, Mike. And before I begin that part, I want to amplify something Mike just said about powers of attorney and supported decision making. And I want to stress again where I was before, which is there's nothing wrong with powers of attorney. There's nothing wrong with guardianship. There's nothing wrong with supported decision making. They're all part of a continuum of choice. And that continuum is dependent upon what the individual needs. Some people need a guardian. Some people need a power of attorney. Others use supported decision making. So often I'm asked, what is the difference? What is the real functional difference between SDM and a power of attorney? And the answer, I think, besides what Mike said, is a very key legal, practical, and moral point. And it's a wrenching point. And it goes like this. People with disabilities are vastly more likely to be unemployed, underemployed, or live below the poverty line. Many simply cannot afford to pay an attorney, let alone a notary public. I'm glad Colin could, to formalize a power of attorney. If we say to them that your right to make choices, a right we all have, is contingent upon your ability to pay an attorney, what does that say about us? And wouldn't requiring that be a violation of the equal protection clauses in the Kansas Bill of Rights and the U.S. Constitution? Bob Dole states better than that. And it can be better still by recognizing the right to make choices through SDM, something that 23 states have already done. So we are not asking you to reinvent the wheel or do something that's never been done before. Since I had the honor to represent a young woman named Jenny, first case to hold that a person had the right to use supported decision-making instead of being put into a guardianship, 23 states That's 2 per year, because that case was in 2012 and 2013, have passed their laws or amended their laws. So Kansas would be joining states as diverse as Alaska and New York, California and Louisiana, Missouri and Maine. And while all of those states laws differ in some aspect, they all stand for the same principle, that people are born with the right to make choice, and that their right to make choices should be respected and protected. But there's even more reasons to legislatively recognize and protect the right to use SDM. Because doing so, as is in the Kansas bill, will provide liability protection for those who honor people's right to make choices. So that if they respect using SDM, they cannot be sued except in very loose. Will provide criminal penalties for those who would attempt to or who do abuse, neglect, or exploit people with disabilities who trust them and use supported decision making. So this bill, this law does more than empower people with disabilities. It protects people without disabilities. It protects businesses. It protects banks and doctors and lawyers who honor supported decision making. But the most important thing that we always must come back to is that if you protect and respect people's right to use SDM, what you're going to do is you're going to empower people with disabilities to create individualized plans, like you heard Colin say, individualized plans and methodologies that will then be honored, that are consistent with their own values and experience, as well as those as their communities and their families, keeping cases out of the courts, empowering communities and families and people. As I've testified before in other states, supported decision-making at its heart means less government and more freedom. And that matters. So to end where I started, you already know why it matters. I've spent a lot of time in Kansas. I've been honored to partner with Evan and KU on a number of projects. I've been to your state many times. And here's something I know. To Kansans, freedom matters. You may remember the Free Britney movement from last year, how so many were surprised and horrified, frankly, that someone as wealthy and famous as Britney Spears could have no right to decide where she lived, whether she worked, or who she could spend time with. And as you've heard today, as you'll see from that video that Mike has forwarded, there are many, many Britneys in Kansas. People lose their right to make choices in Kansas through guardianship at roughly twice the national average. They're not celebrities like Britney. They're your neighbors. They're your family members. They're your friends. They're straightforward Kansans. People who hunger for something that you have right now. The simple right to choose how they spend their days and their nights, and to choose the people who help them do that. Senator Dole said, and I quote, "Having a disability changes your whole life." He was a driving force behind the Americans with Disabilities Act, a law that promised equal opportunities to people with disabilities. You can continue what he started. You can empower people with disabilities to be full and equal members of society with the same rights as every other citizen. We pray that you'll do so. Thank you so much for your time and your consideration. I'll be happy to answer any questions if you have them.
Well, thank you. And so just to wrap up, so where we're at is essentially still the starting point, kind of as Elizabeth alluded to earlier. We still have a lot of work to do to help get the word out about supported decision making. We will have an opportunity to look, hopefully bring Kansas in line with what 23 other states have done, where they've realized, I mean, like here in Kansas, we have this today. Unfortunately, businesses don't have those liability protections. Supporters do not have liability protections. We don't have the enhanced penalties. And so those are things potentially to consider, but we're also doing outreaches. We're reaching out to educators. We're trying to, I'm happy to say our organization is going to be partnering with the Kansas Bar Association to develop some CLEs on disability issues, including supported decision-making and alternatives to guardianship. So we're beginning some of this process. And so that one of the other new things, we have a new resource that where you can go to find the video, idecideKansas.org, which should be attached to my testimony. But ideally, you can go there and spend 10 minutes, or anyone can, to spend around 10 minutes and get an idea of what supported decision-making is and find additional resources if they want to learn how to use it or begin using supported decision-making with the loved one. So with that, Mr. Chair, I'd be happy we'd be happy to stand. I mean, we have the experts here if you have any, if the committee has any questions.
And committee, you do have the contact information in your email for everyone. So if there's questions you want to ask offline, you're sure encouraged to do so. But since they are here, do we have a couple? We have time. We don't have time, but we're going to take time for a few quick questions. Representative Carmichael.
Thank you, Mr. Chairman. I entered the room somewhat amenable to this legislation, but I must tell you, the testimony that I've heard here causes me more concern than it does reaffirms my thoughts. Nothing is less persuasive to me than out-of-state lawyers zooming in by WebEx to tell me what the law in Kansas ought to be, when we have very well qualified practitioners in this state who practice in the area, this very area of the law every day, and service their clients. And so, number one, it starts off with a bad opinion, but then I realize that the reason we have guardianship statutes is to protect vulnerable citizens from abuse. Abuse by caregivers, lawyers, professional guardians, friends who serve as guardian. And that's, of course, why we have accountings. And that's why we have court supervision. And now you tell me that the bill that you're bringing is going to grant immunity so that the people who've been victimized, the people under disabilities who've been victimized by folks who are no longer under the supervision of the court, can't bring a lawsuit to recover the damages. And this concerns me greatly. So I haven't seen your bill, but I'm not nearly as favorably inclined as I was before this hearing started. Thank you, Mr. Chair.
Other questions, committee? Okay, I do encourage you to, if you have questions, reach out to those that provided us information today. If you can't find their contact information, let me know or let Mike know. I guess I don't have to close the hearing because it's not a, well, maybe I do. I don't know. No, it's not a real hearing. I'll close the informational briefing. Committee, bill request. I have one that I overlooked. It is dealing with the open records. We do this every year. We caught it this time. So it's RS 1014. Fairly routine bill we have every year that when a new exception to the Open Records Act goes on, it sunsets after 5 years. Yes, after 5 years. So we look at that, and that's what this bill will do. Any questions or objection? We'll get that in. Anyone else come up with any great ideas and get an RS number in the last 90 minutes? Okay, we're done with requesting bills. That's it for today. Thanks, everybody. We'll see you tomorrow.